1-2-0-1 matters before the court today for an arraignment. May I have your appearances, please, starting with the prosecution.
Carolyn Solari, P number 86651 for the people.
Thank you.
Good morning, Your Honor. Alexandra Miller, P86290, on behalf of Mr. Christopher Lloyd, who is present via telecommunications device. Mr. Lloyd, can you please state your name for the record?
Christopher Lloyd.
One more time, a lot louder, sir.
My name is Christopher Lloyd.
All right, thank you. And for the purpose of arraignment, Attorney Miller, how would you like to proceed?
Yes, Your Honor. For purposes of arraignment, we waive formal reading of the charges, stand Mr. Lloyd mute, and ask that any capias in this matter be recalled.
All right, thank you. Court will do exactly that. Court will recall any capias. Court will enter a not guilty plea on behalf of Mr. Lloyd. And Madam Prosecutor, what is your pleasure at this time?
Your Honor, the people would just be requesting a higher bond as this matters in capias status for some time now.
Well, okay. So as it relates to that, court's not going to, I guess, set a high bond on that basis. I note that although the complaint was authorized and issued back in 2015, Mr. Lloyd was never arraigned on this particular case. So at least by my reading of the court file, he has not appeared in court on this matter through no fault of his own. Further, the court understands that Mr. Lloyd is currently incarcerated. At this time, it may have been shortly thereafter this complaint was issued. So anything further as to bond, Attorney Solari?
No, Your Honor, thank you.
Attorney Miller?
Nothing further as it pertains to bond, Your Honor. Covered exactly what defense would argue. So nothing further as it relates to that.
Okay, so this is what the court is going to do. We'll set, let me open this calendar here first. We're going to set a pretrial conference in this case. Let's make that for a couple weeks from now. Let's say June the 14th. Does that work for you, Attorney Miller?
As long as it is in the morning docket, Your Honor, it does.
It'll be at 8:30 in the morning. It'll be via Zoom.
Wonderful.
Court does want the complaining witness present if the people are going to proceed in this case with that individual's assistance. Court's going to set bond at a $1,000 personal bond, no contact with the complaining witness in this matter, that person being a Jewel Sanders. And we'll see where we are on the 14th of June in this particular case. Anything further from the people?
No, Your Honor.
Miller?
Nothing further from the defense at this time, Your Honor. I appreciate the court's patience in getting Mr. Lloyd on the telecommunications, and I thank your clerk for her hard work in making that so.
Wonderful. So appreciate that. We'll see you in a few weeks. Have a good day and be well.
All right. Thank you. You as well, Your Honor.
Thank you. Have a good day, Mr. Lloyd.
Too.
Thank you. So now to our regularly scheduled programming, which would be, I don't know, I think I got Grady at the jail. I think that's who that is. Let's see.
Your Honor, Anthony Hales is in the hallway. We're ready on that matter when the court is. I'm also ready on Mr. Grady.
What happened that we didn't do that yesterday? Oh, yeah.
We did, Your Honor. It's another matter.
Okay. Good morning. May I have your name, please, sir? There at the
Louis
jail.
Clark.
One more time for me.
Louis Clark.
All right. Thank you. Mr. Clark will be with you in a moment. Attorney Robertson, you need to speak with Mr. Clark.
Yes, could you put him in with the other attorney with our office, though?
Sure.
Thank you.
All right, Mr. Clark, send that device a link to a breakout room. I want you to click join. When you see it, you should see that right about now.
Morning, Your Honor.
Good morning, Attorney. So I don't have Grady. I don't know who this individual is. I do have a Jason Murray.
Ready, Your Honor.
Are the people ready on Jason Murray?
One moment, Your Honor.
I also have P. Samuel Wingfield and counsel one, Attorney Solari.
I'm sorry, Your Honor.
I also have the trial that's docketed for today. I have those individuals on Zoom currently. It's my understanding that the goal is to take a plea. I guess there was an offer in that manner.
Yes, Your Honor, that is correct.
Okay, so we can do that one first if you need some time on Murray.
Your Honor.
Attorney Davis, are you there? Good morning, Mr. Wingfield.
Good morning, Your Honor.
Yes, good morning.
All right, so let us go on the record. The court calls the people versus P. Samuel Wingfield. It's case number 220-451-5701. Matter is docketed for a trial on today. May I have your appearances, please, starting with the prosecution.
Carolyn Solari, P number, sorry, Your Honor, 86651 for the people.
Thank you.
And Maurice Davis, P 76203, appearing with P Samuel Wingfield, who's present appearing via Zoom. Mr. Wingfield, state your name for the record.
P. Samuel Wingfield.
All right, thank you. And today is the date and time set for a trial in this matter, but it's the court's understanding that there's been an offer and an acceptance in this case, Attorney Davis?
Yes, we originally offered 7694A. Is that correct, Madam Prosecutor?
I'm so sorry. May I have one moment, Your Honor, and Attorney Davis?
Sure.
Sure.
I apologize, Your Honor. I am not aware of an offer that was made. I don't have anything. Was it a different prosecutor, Attorney Davis?
Okay. I can't recall who the prosecutor was that was covering on our pretrial date.
So the people don't have any record of this is what we'll do. We'll pass on this matter for a moment and allow some other work to get done on that, and then we'll be with you in a moment. Appreciate your patience.
Okay.
All right, Attorney Roberts is in a breakout room. All right, I'm gonna check these folks and then we can do Murray. To the extent that I'm able to check anybody in. Good morning. May I have your name, please?
Rayshawn Gray.
Thank you, Mr. Gray. We'll be with you in a moment. All right, Mr. Clark will be with you in a moment. This person has not said anything. We're going to remove them. All right, let's do Murray. All right, so let us go on the record. The court calls the People versus Jason Allen Murray's case number 230-446-9401. Matter is set for a pretrial conference on today. May I have your appearances, please, starting with the prosecution?
Carolyn Solari, P number 86651 for the People.
Thank you.
Good morning, Andrea Roberts, appearing on behalf of Mr. Murray. Mr. Murray, can you state your name?
Jason Allen Murray.
All right, thank you. And today is the date and time set for a pretrial conference in this matter. Madam Prosecutor, what is your pleasure in this case?
Your Honor, to note for the record, the People were in touch with the complainant and she was to appear today. So we'd be asking for a final pretrial date to be set.
Attorney Roberts.
Your Honor, we move for dismissal in the absence of the complainant, especially if she was notified and failed to appear today.
All right, thank you. Any response, Madam Prosecutor?
Your Honor.
I'm sorry, I didn't hear you.
Your Honor, we can still proceed without the complainant witness being present at the first pretrial hearing.
All right, so this is what we're going to do in this particular case. The court is going to deny the motion to dismiss on today. Instead, what we'll be doing is continuing Mr. Murray's not guilty plea. We'll set this case for a final pretrial conference. Let's make that on Wednesday, June 14th. That'll be at 9 a.m. The court does want the complaining witness present if the People are proceeding in this matter with that individual's assistance, and will do so as needed at that date and time. Anything further from the People?
No, thank you, Your Honor.
Anything further, Attorney Roberts?
Yes, may I address bond, Your Honor?
You may proceed as to bond.
Your Honor, I would ask at this time for you to remove the tether condition. It's my understanding that Mr. Murray indicates being 42 years old and not having any prior criminal convictions. He's currently staying with his cousins in Hazel Park, understands not to have any contact with the complainant. He is employed, Your Honor. He works as a customer service representative. In the absence of the complainant to contest removal, I am definitely asking that you consider it at the time.
All right, thank you. Attorney Solari, any response from the People?
One moment, Your Honor. Ms. Roberts, you indicated no assaultive conviction, is that correct?
No, I said he indicates no convictions.
Okay, that would be inaccurate. So, Your Honor, the People would respectfully object to Ms. Roberts's attempt to modify bond as the report, the investigative report indicates or alleges that the defendant came to the complainant's home and was harassing her. And on top of that, although the will understand that he has no assault history, the people are a bit concerned as to why he would withhold any information of that matter from his attorney.
Okay, any last words, Attorney Roberts?
Your Honor, I guess if the people are bringing up the priors, I would ask that they put on the record what that is.
Yeah, let's do that, Madam Prosecutor. What do you have that evidently Attorney Roberts did not have?
Your Honor, the people would again note that Attorney Roberts indicated that he had no history whatsoever. So in addressing that, in 2008, he pled no contest to a misdemeanor while operating a vehicle with his license revoked. As well as in 2005, he pled guilty to a misdemeanor operating while impaired. And that's what I see from my end at this point, Your Honor.
Thank you.
So as I indicated, no assault of history.
Anything else, Attorney Roberts?
Your Honor, those both sound like traffic related offenses. And so again, I would ask the court to remove the tether. I don't think those are relevant to the hearing.
Thank you all. So of course, heard from both the people as well as defense counsel in this matter. Court has reviewed the court file and the allegations contained therein. Allegations consistent with the people's presentation that the defendant, Mr. Murray, did arrive at a location where the complainant was, and allegedly the assault and incident ensued from there. The court is at this point going to continue bond in this particular matter, and will continue this case to the 14th of June. Anything further, Attorney Roberts?
Not at this time, Your Honor. Thank you.
Attorney Solari?
No, thank you.
All right, Mr. Murray, you have a good day and be well. We'll see you in 2 weeks.
All right, thank you.
People on here. Murray, we did. That we did. Lewis Clark.
The people are ready, Your Honor.
Ready, Your Honor.
All right, the court calls the people versus Lewis Clark, case number 230-446-8601. Matter set for a pretrial conference on today. May I have your appearances, please, starting with the prosecution?
Carolyn Solari, P number 86651 for the people.
Thank you.
Good morning, Anthony Roberts appearing on behalf of Mr. Clark. Mr. Clark, can you please state your name for the record?
Lewis Clark.
All right, thank you. And today being a daytime set for a pretrial conference, what is your pleasure, Madam Prosecutor?
Your Honor, the people would respectfully ask this honorable court to set a final pretrial date.
Thank you, Madam Defense Counsel.
Your Honor, I would respectfully move for dismissal in absence of the complainant today.
Of course, going to at this time deny the motion to dismiss. Instead, what we would do is continue Mr. Clark's not guilty plea. Set this matter for a final pretrial conference. That'll be on June 14th. That'll be at 9 a.m. Court does want the complaining witness to be present at that date and time, and we'll see how the people would like to proceed then. Anything further from the people?
No, thank you, Your Honor.
Attorney Roberts,
Yes, Your Honor, may I respond?
you may proceed as to bond.
Your Honor, it's my understanding that Mr. Clark had a redetermination hearing on May 24th, I believe. And at that court hearing got a personal bond with a tether. I am respectfully asking that you consider removal of the tether at this time, with the provision that Mr. Clark had no contact with the complaining witness. My understanding that he is 31 years old, that he is working, Your Honor, working 2 jobs prior to being incarcerated. And at this time, we're asking that you allow him to be released on this matter without any tether.
All right, thank you. Any response from the people?
Your Honor, the people would just like to clarify, is Mr. Clark in custody with the tether, or is he being released today?
I wouldn't know about whether there is a release date or not. Obviously, he's at the Wayne County Jail today. Attorney Roberts.
Your Honor, I would ask the people to ask the sheriff if they want that clarification.
Is there a deputy by you, Mr. Clark?
Yes, sir.
This is George Garrett.
How you doing this morning?
Doing fine, sir.
Is Mr. Clark in line for a tether?
Yes, but I'm gonna call to see exactly where he's at because he should have been gone by now.
Okay. All
I'm
right.
gonna get with the tether sergeant today, and let him know where he's at on the list.
Okay. Thank you. Madam Prosecutor, do you have any further questions as it relates to tether eligibility or timing of a tether?
No, thank you,
All right.
Deputy, and thank you, Your Honor.
All right. So, Madam Prosecutor?
Your Honor, the people would strongly object and believe that the defendant necessitates a tether. In reading the investigative report, the report alleges that the defendant struck the complainant multiple times and strangled her to the point where she had a seizure and lost consciousness. So we would be asking that the tether remain.
Thank you. Courts heard from defense counsel. Courts also heard from people in this particular matter. In addition, court has reviewed the court file and the allegations contained therein. Court is going to continue bond in this matter at this time, and we will see Mr. Clark again on the 14th of June, 9 a.m. All right, Mr. Clark, have a good day and be well, sir. See you in 2 weeks.
So I'm still getting tethered or no tether? I'm sorry.
There is still a tether order, sir.
Okay.
All right. Have a good day.
Thank you, Your Honor.
All right. Who else do we have here?
Your Honor, could you put Mr. Haywood in a breakout room with Ms. Scheid, please?
Sure. Good morning, sir. May I have your name, please?
William Willis.
One more time for me.
William Willis.
All right, Mr. Willis will be with you in a moment.
Could I talk to Mr. Willis, please, Your Honor?
All right, Mr. Willis, your attorney wants to speak with you before we move forward. Click join. Still room for Attorney Roberts.
Thank you.
Good morning. May I have your name, please, sir?
De'Anthony Shelby.
All right, Mr. Shelby will be with you in a moment. Madam Prosecutor, any word as it relates to Wingfield?
Your Honor, I haven't had a moment to speak with the defense counsel, if I may.
Sure. Attorney
Thank you.
Davis, click join.
Your Honor,
Yes, ma'am.
the people are ready to proceed on Wingfield.
Okay.
Is.
Yeah, not a problem. You can take it.
All right, so let us go back on the record in the People versus P. Samuel Wingfield. Again, this is case number 220-451-5701, matter before this court today, docketed for a trial. May I have your appearances yet again, please?
Thank you, Your Honor. Carolyn Solari, P number 86651 for the People.
Thank you.
And Maurice Davis, P 76203, appearing with Mr. Wingfield, who's present appearing via Zoom.
All right, Mr. Wingfield, may I have your name, please?
P. Samuel Wingfield, Your Honor.
All right, thank you. And Madam Prosecutor, there's been an offer made in this case?
Yes, Your Honor. It's the People's understanding that the defendant would like to plead guilty pursuant to section 7694A with a probationary term of 6 months, with the terms to be determined by the probation department and restitution to be determined by the probation department.
All right, Attorney Davis, is that your understanding of the People's offer in this case?
Yes, it is.
All right, Mr. Wingfield, is that your understanding of the People's offer in this case?
Yes, Your Honor.
And that is the offer that you're seeking to accept on today?
Yes, Your Honor.
You raise your right hand for me. Do you swear or affirm to tell the truth and nothing but the truth shall help you?
Yes, Your Honor.
Excuse me.
I do.
Sorry, one more time, sir. Do you swear or affirm to tell the truth and nothing but the truth so help you?
Yes, Your Honor.
I do.
All right, you can. What in the world? Everybody but the person I'm talking to, or along with. All right, Mr. Wingfield, you understand that you do have a right to a trial in this case.
Yes.
And today you are waiving or giving up your right to a trial by accepting the offer from the prosecution and pleading guilty.
Yes.
You're doing so voluntarily, knowingly, and intelligently.
Yes, Your Honor.
No one has promised you anything or threatened you in any way to get you to do so.
No, Your Honor.
You're doing so on your own free will.
Yes.
And you understand that once the court accepts your plea, that there will be no trial of any kind in this case.
Yes, Your Honor.
You understand that by offering this court a guilty plea on today, you are waiving or giving up your right to have the people prove beyond a reasonable doubt that you are guilty in this case.
Yes.
You're waiving or giving up your right to cross-examine or question any witnesses and or review any evidence that the people would put forth support of their case.
Yes.
You're waiving or giving up your right to have witnesses testify on your behalf.
Yes.
You're waiving or giving up your right to remain silent and not have that silence be used against you.
Yes.
And you're doing so on today with the understanding that a conviction for the crime of domestic violence does carry up to 93 days in jail and or a $500 fine.
Yes.
And you're offering this court a guilty plea on today nonetheless.
Yes, Your Honor.
And you're offering this court a guilty plea on today because you are in fact guilty.
Yes.
And so as to count one domestic violence, sir, how do you plead? Guilty or not guilty?
Guilty, Your Honor.
All right, thank you. Attorney Davis, do you have the file for the factual basis in this matter?
I can do the factual basis. My file is downloading. My computer's moving kind of slow, but I'll direct your attention to the date and time is written on the complaint. Were you in the city of Detroit, Mr. Wingfield?
Yes,
Were you with a individual you were in a dating relationship with?
yes,
Okay, who's that individual?
Deanna Campbell,
Okay, how long were you in a dating relationship with her?
about a year and a half, 2 years.
And at some point there was an altercation, is that correct?
Yes,
And that altercation turned physical, is that correct?
yes,
And you struck Miss Campbell,
yes,
and that was without her permission, is that correct?
that's correct.
All right, Madam Prosecutor, you satisfied with the factual basis?
Yes, Your Honor.
All right, court is also satisfied and will accept the factual basis as well as Mr. Wingfield's guilty plea as to count 1 domestic violence. As such, we will set a sentencing date in this particular case, and that will be approximately 6 weeks from today, being the 31st. Let's come back on the 12th of July, if that works for you, Attorney Davis.
Yes, that works.
All right, so that'll be July 12th at 10 a.m. The court is ordering a pre-sentence interview and a substance abuse evaluation for Mr. Wingfield prior to sentencing, and will move the matter along as needed at that date and time. If the complainant in this case would like to make a statement, written or otherwise, Madam Prosecutor, Attorney Solari, the appropriate time to do so is the sentencing date of July 12th. Anything further from the people?
No, thank you, Your Honor.
Attorney Davis.
Is it possible for my client's pre-sentence interview to be conducted remotely? He's in the military and he's currently in Fort Hood.
I think they allow that via Zoom. That shouldn't be a problem.
Okay.
All right. You have a good day and be well.
All right, you as well.
Thank you. Good morning. May I have your name, please?
Carlonda Ravenel.
I'm sorry, one more time for me.
Carlonda Ravenel.
All right, thank you. We'll be with you in a moment.
Yes, sir.
Are the people ready on Shelby?
Yes, Your Honor.
Your Honor, can you put Mr. Shelby in a breakout room with Ms. Shive? I am ready on Haywood. And we have a couple of people in the hallway as well. Also ready on Mr. Willis.
All right, well, let's do Willis.
Thank you.
Hello.
Click join, Mr. Shelby. All right, so the court calls the people versus William Willis, case number 230-446-8701, matter set for a pretrial conference. May I have your appearances, please, starting with the prosecution.
Carolyn Solari, P number 86651 for the people.
Thank you.
Good morning, Iadra Roberts appearing on behalf of Mr. Willis. Mr. Willis, can you please state your name?
William Willis II.
All right, thank you all. And Madam Prosecutor, what is your pleasure at this time?
Your Honor, the people would respectfully request that this honorable court set a final pretrial date.
Thank you, Attorney Roberts.
Your Honor, we move for dismissal in absence of the complainant today.
All right, thank you. The court at this time is going to deny the motion to dismiss at this on today. Instead, what we do is continue the not guilty plea entered in this matter. We'll set this case for a final pretrial conference. That'll be on June the 14th. That'll be at 9 a.m. Court does want the complaining witness present if the people are proceeding in this matter with that individual's assistance, and will do so as needed at that date and time. Anything further from the people?
No, thank you, Your Honor.
Anything further, Attorney Roberts?
Yes, Your Honor, may I address bond?
May proceed as to bond.
Your Honor, I respectfully ask that you consider removal of the tether. Mr. Willis understands not to have any contact with the complainant. He indicates he has an alternate place to stay while this matter is pending. That's not with her. He also indicates he does 2 jobs, Your Honor, event management and maintenance, and with the moving service. So we're asking that you consider removal of the tether and continue a no contact order.
All right, thank you. Any response from the people?
One moment, Your Honor. Your Honor, defendant was charged, this is his second offense as it relates to domestic violence. His first offense was charged back in 2020. And then as it relates to this, the people note that the investigative report alleges that the defendant grabbed the complainant by her neck and both hands and strangled her. So the people would respectfully object to Ms. Roberts's or Attorney Roberts's argument for modification for bond.
All right, thank you. Courts heard from the prosecution. Courts also heard from defense counsel on today. Court has also reviewed the court file and the allegations contained there. And court is going to continue bond in this particular case, and we'll see where we are on the 14th of June at 9 a.m. via Zoom. Thank you and have a good day, sir.
Thank you.
Thank you, Your Honor.
I'm at a loss on Mr. Haywood.
Your Honor, that's a KPS. There was Mr. Haywood, Ms. Wesley, and James White that the court said could appear today.
If that's the case, wasn't he supposed to be here in person then?
Well, you made an exception because he lives in Tennessee, from my recollection.
Oh, okay. Well, if I said that and he's in Tennessee, then that sounds reasonable. Who's in the hallway?
Miss Wesley and Miss Marion Smith from yesterday.
Okay. What about, are the people ready on Gray or Ravenel? Well, not Gray, Ravenel.
People are ready, Your Honor.
Attorney Roberts, are you ready on that matter?
Your Honor, to remind the court, Mr. Ravenel exceeded our guidelines for representation.
Oh, okay. That's perfect then. Thank you. So I'll step into the courtroom and see who we have there. Thank you.
Thank you.
All right, so let us go on the record. The court calls the people versus Anthony Hales, case number 0905814501. Matters before the court today for a pretrial conference appearance, please starting with the prosecution.
Plea number 86651 for the people.
Thank you.
Good morning, Erica Roberts, appearing on behalf of Mr. Hale. Mr. Hale, can you state your name, please?
Anthony Hale.
All right, thank you. And what is your pleasure at this time, Madam Prosecutor?
Your Honor, the people would be asking for a final pretrial date instead.
Thank you, Attorney Roberts.
Your Honor, we move for dismissal in the absence of the complainant and would like to emphasize to the court that this matter goes back to an incident date of February 9th, 2009.
Thank you. So at this time, the court is going to deny the motion to dismiss. Instead, what we'll do is continue the not guilty plea entered in this particular matter. We'll set this case for a final pretrial conference that will be on the 14th of June. That'll be at 9 a.m. The court does want the complaining witness present if the people are proceeding in this matter with that individual's assistance, and will do so as needed at that date and time. Anything further from the people?
No, thank you, Your Honor.
Attorney Roberts.
Not at this time, Your Honor. Thank you.
Thank you all. Mr. Hale, you have a good day and be well. We'll see you in 2 weeks.
Thank you.
No, you want to present your person? Or Zoom? Okay, I'll be here.
Yeah.
Okay, thank you. Okay.
Thank you.
Smith. Is Smith yours? Madam Prosecutor? Oh,
I'm sorry, Your Honor.
nothing. All right, so the court calls the people versus Marion Smith. It's case number 230-441-1801. Matter is docketed today for a continuation of the final pretrial conference. May I have your appearances, please, starting with the prosecution.
Carol Solari, P number 86651 for the people.
Thank you.
Good morning, Your Honor. Angela Roberts, appearing on behalf of Ms. Smith. Ms. Smith, can you state your name, please?
Marion Smith.
All right, thank you. And Attorney Roberts, what is your pleasure at this time?
Your Honor, I would respectfully ask that you consider an adjournment of this final pretrial conference. We would like the opportunity to continue to discuss this matter with Ms. Smith. The people have made an offer. We would like to further discuss the case with her.
All right, what is that offer, Madam Prosecutor?
One moment, Your Honor.
Or Attorney Robertson, what is the offer?
Your Honor, my understanding of the offer is that the people would be amenable to a no contest plea to the domestic violence charge and dismissal of child abuse charge.
Okay. Is that accurate?
One more, if I could just have one more,
Sure.
Your Honor. Yes, Your Honor, but the people's understanding is that that offer is expired today.
Okay. Attorney Roberts?
Well, Your Honor, if they're making that decision, I guess there's nothing we can do about it.
All right, so what's your pleasure?
Ask the court to either recall this matter or set it for a jury trial, Your Honor.
All right, well, we'll give you a moment to consider. You can have step in the hallway for me, okay, man?
Is there a reason why it's expired?
Supposed to do last time.
Yeah.
And she didn't know.
And we're at the first. Go ahead. Just go ahead and call. Ms. Wesley, Your Honor.
Wesley?
Yes.
Do I have that? Good morning, Attorney Cole. How are you?
I'm fine, Judge. How are you?
Doing just peachy. the case number for that?
230-445-2201.
Yeah, Wes.
Thank you.
Yeah.
230-445-2201.
Thank you.
This should be Attorney Hales matter, right?
Oh.
Judge, you want me, please?
Sorry. All right, so the court calls the people versus Ramira Wesley is case number 230-445-2201. Matters before the court today in warrant status. May I have your appearances, please, starting with the prosecution.
I'll call on behalf of the people.
Thank you.
Good morning, Angela Roberts, appearing on behalf of Ms. Wesley. Ms. Wesley, state your name, please.
Ramira Wesley.
All right, thank you. Court will recall the warrant and set aside cases in this matter as the defendant has made an appearance on this particular case after failing to appear at the docketed final pretrial conference on May 16th of this year. What is your pleasure otherwise, Attorney Roberts?
Your Honor, I don't know if the court would entertain any motion to dismiss if the complainant was not present last time. Otherwise, we ask that you set this for a final pretrial, again, for complainant to be present.
All right, thank you. What say you, Madam Prosecutor?
Yes, I would ask that we also set it for a final pretrial, Your Honor.
All right, thank you. What we'll do is this, we'll set the case for a final pretrial conference. That'll be on June 21st. That'll be at 9 a.m. Again, the court does want the complaining witness present if the people are proceeding in this matter, and will do so as needed at that date and time. Anything further as to bond, I guess, Attorney Roberts?
Your Honor, I'm asking for a personal bond. My recollection of what happened last time is that Ms. Wesley did try to log in, but the meeting was loud because it was too late. I believe that she had overslept and then has a 1-month-old baby, which she tried to get back to sleep and ended up falling back to sleep. So we do apologize on her behalf, but we ask the court to understand. I don't think it was an intentional situation, and she is here to try to address this matter. So I'm hoping you would consider giving her a personal bond.
Thank you. Any response from the people?
The people would have no objection at this time, Your Honor.
All right, thank you. Court will set a $500 personal bond, no contact with the complaining witness, and let's have our final pretrial in person.
Thank you, Your Honor.
All right, we'll see you in a few weeks, man. Have a good day as well.
Yeah, or in person next time again, okay? Okay, thank you.
Is that everyone that was in the hallway?
I believe so. Can I just step out for 1 second with Ms. Smith down the Ms. Smith's number?
Sure. Good morning. May I have your name, please?
Good morning, Javonte Amos.
One more time for me.
Javonte Amos, Amos.
All right, Mr. Amos will be with you in a moment.
Okay.
Good morning. May I have your name, please, ma'am?
Sheena Edwards.
One more time for me.
Sheena Edwards.
And will you spell that for me?
Sheena. Last name Edwards, EDWARDS.
All right, thank you, ma'am. We'll be with you in a moment. Joseph Fields.
Can I talk to Mr. Fields, please?
All right, so this is what I have on. I have
Okay.
Haywood,
Ready?
Fields,
Need a minute.
Javonte, Amos. I have Ravenel and Gray as well, but Attorney Roberts, you aren't on.
I was gonna say, I'm not sure what Mr. Gray is, but.
Mr.
yes, I
Gray
know that
has
one.
Attorney DiMaggio. Who's on.
Got it, okay. So I'm ready to call Haywood. I would like some time for Amos and Fields,
Okay.
please.
What's the case number for Haywood?
You ready? 9706176001. Arnold Haywood.
Person that advocated for me was Great Mathis. Judge Mathis.
You do not happen to have the file on this, do you?
No, I do not.
Okay. So does what you have just say pled guilty and then a warrant was issued, or found guilty and a warrant was issued? That's all I could gather.
Yeah.
Okay. So I think then maybe we need to send another date with the file, or
Clerk.
can't tell. There's
Mr. Haywood, can you hear me?
Hello?
Mr. Haywood, good morning. Can you hear me?
I can't barely. Let me see if I can go someplace where it's a little quieter. Okay, I can see you, hear you now. I can hear you.
All right, so let us go on the record. The court calls the people versus Arnold Haywood. Is case number 97061760001. Matters before the court today in warrant status appearances, starting with the prosecution.
Carolyn Solari, P number 86651.
Thank you.
good morning, Your Honor. Andrea Roberts, appearing on behalf of Mr. Haywood. Can you state your name again, Mr. Haywood?
Yeah, Arnold Haywood.
Thank you.
All right, court will recall the warrant says that. What is your pleasure otherwise, Attorney Roberts?
Your Honor, the limited information I have in this matter is that she was found guilty as charged on November 19th, I think 97, and a warrant was entered February 11, 2013. So at this time, I'm just would like the case to be called that you did, and perhaps we set another court date so we can see if he was sentenced or if he was if he missed a review date, or what exactly happened when the warrant was issued.
All right, thank you. Do people have a position on that?
No objection, Your Honor.
All right, so what we'll do is this court will set this case for what will term a review on the 14th of June. That'll be via Zoom, and that'll be at 10 a.m. And we'll see where we are at that day and time as to what the appropriate next steps need to be in this particular case. Anything further from the people?
No, thank you, Your Honor.
Anything further, Attorney Roberts?
Your Honor, I would ask for a personal bond and that the court allow Mr. Haywood to appear via Zoom, as it's my understanding that he does live in Tennessee at this time.
All right, thank you. Any response from the people?
People would have no objection.
Enter a $1,000 personal bond, no contact with complaining witness, and the court is continuing, I guess, or allowing Mr. Haywood to continue to reside, not in the state of Michigan, but in, you said Tennessee?
Yes, Your Honor.
All right, so we'll see where we are in 2 weeks, okay, Mr. Haywood?
Okay, hey, I can't say anything, can I?
Not right now. You said something, Madam Prosecutor?
Yes, Your Honor, would be asking for a reiteration of the no contact order as a lot of times passed.
Right, so, Mr. Haywood, you're not to have any contact with the complainant, in this case, that person being a Ms. Barner. You understand that, sir?
Yes. That's
Okay.
what I was saying, Your Honor. I was sentencing everything to a year probation. And I did everything. They just never removed it from the computer.
Okay, so I thank you for that information. Once we have confirmed that, we'll know what to do on the 14th. Okay, sir?
All right.
All right, you have a good day and be well.
All right, thank you.
Who else do we have?
Mr. Shelby, did we lose Mr. Shelby?
Mr. Shelby is in a breakout room. Are the people ready on Shelby?
Judge, Dr. Williams in the hallway.
Yes, the people are ready. Mr. Shelby?
De'Anthony Shelby.
Anthony Shelby, sorry about that, Your Honor.
All right, so the court calls the people versus De'Anthony Shelby. It's case number 210-455-8501. Matter is before the court today for a pretrial conference. Appearances, please, starting with the people.
Carolyn Solari, P number 86651 for the people.
Thank you.
Anthony Roberts is hearing on behalf of Mr. Shelby. Mr. Shelby, can you state your name? Unmute your device, please.
De'Anthony Dwayne Eugene Shelby.
All right, thank you. And how are we proceeding on today, Attorney Roberts?
Your Honor, I know that this is docketed for a pretrial. However, my further review of this matter is that Mr. Shelby had unfortunately taken the sentencing date. And so at this point, I will respectfully ask that the court consider re-referring Mr. Shelby for a pre-sentence report and another sentencing date. And it's my understanding that maybe I should address bond after the court makes that decision.
All right, so I note that it should be for a review. I note that sentencing was set for November of last year, November 18th, 2022. And Mr. Shelby failed to appear at that point. I further note that there was no PSI provided. In fact, there was a supplemental report from November the 18th indicating that appointments were set, but Mr. Shelby didn't make any of them.
Your Honor, I believe though they said that he did actually report once and the writer was out sick.
Right, on the 1st of November. So this is what we'll do. We'll re-refer Mr. Shelby and we'll come back on the, what's 6 weeks from today? Let's come back on the 12th of July at 10 a.m. That'll be in person for sentencing.
Okay.
Connor, would you please give me the date?
July 12th, 10 a.m. And that's here at 36th District Court, 421 Madison, Detroit, Michigan, 48226 in this courtroom, 338. As to bond,
Your Honor, I believe that Mr. Shelby is currently on a tether, and I would ask that you consider removing it. It's my understanding it's not only uncomfortable for Mr. Shelby, but it's actually, like on his bone at this time. And also, he can't afford it. He's indicated that it costs $300 down and $100 a month. And he has indicated no contact with the complaining witness. Also, Your Honor, it's my understanding he's struggling, he does not have transportation, and he's being honest in admitting that the reason he failed to return was because he was scared. But I'm hopeful, Your Honor, that he's back on track now. Since then, he's obviously had to go through getting arraigned on this case, going through the DDC and getting back on track. So I'm asking that you consider taking Mr. Shelby at his word, setting this court date in person. I think going through this experience has taught Mr. Shelby what happens if you fail to appear for your court date. And so I'm just asking that you take into consideration what Heather is actually doing to him, as well as his inability really to afford it.
Yes, Your Honor, the people would just like to first note that as this case has been in warrant status for some time, the case was, right now, our office is in the process of going paperless, so I do not have the file, and that's what it's currently in progress of being scanned in. The last our office spoke with the complaining witness was on January 27th, and at that time, she reported to APA Gregory Tush that she was receiving threats from the defendant on or around January 19th, 2023. So that is the last contact we had with the complainant, and we would just ask that the bond be continued, as this is a domestic violence case, and again, this case has been in warrant status for some time now.
all right, thank you. All things considered, the court's going to continue bond in this case. Maybe the court will reconsider the tether at sentencing, or in the event that Mr. Shelby does in fact have an appointment, have the PSI scheduled and completed. But at this point, the court has very little confidence in Mr. Shelby's ability to appear and do what he needs to do without some type of monitoring device on him at this point. So of course, we're going to continue bond in this case. Anything further, Attorney Roberts?
Not at this time, Your Honor. Thank you.
All right, Mr. Shelby, we'll see you in about 6 weeks. You have a good day and be well.
You do the same. Thank you, Judge.
Okay.
Good morning, may I have your name, please, sir?
Thomas Flowers.
All right, Mr. Flowers will be with you in a moment.
Okay.
Madam, may I have a moment?
Sure.
Thank you.
Attorney Roberts, who do you need breakout rooms with?
Fields, Amos, Flowers. Please and thank you.
You said Flowers?
Yes, and Fields and Amos.
Okay.
Thank you.
All right. If you receive a breakout room link, click join. Mr. Ravenel, are you there? All right, so let us go on the record. The court calls the People versus Carlonda Ravenel's case number 230-443-8701. The matter is before this court today for a continuation of the final pretrial conference. May I have your appearances, please, starting with the prosecution?
Carolyn Solari, P number 86651 for the People.
Thank you. May I have your name, please, sir?
Carlonda Ravenel.
All right, thank you. And Mr. Ravenel, we were last here on the 1st of the month. You were informed at that point that your income exceeded the guidelines for an appointed attorney. I don't have an appearance in the file for an attorney on your behalf. Are you seeking to proceed in this matter without the representation of an attorney, sir?
No, I was gonna ask, can I get a extension so I can try to find one that is affordable? Like I said before, I wasn't able to afford an attorney. No one wanted to listen to what I was trying to say. So I'm still looking for an attorney as we speak, someone that I can afford. Unfortunately, I had a heart attack right before I had court with you guys. So I've been in the hospital. I have no money. So I was trying to tell the people that they didn't want to listen to me at all. So nobody wants to listen to me. I can't afford an attorney, but like I said, I can try to get a second job to get an attorney, sir. So other than that, that's all I can tell you.
All right, Madam Prosecutor, how are you seeking to proceed on today?
Your Honor, the People would be looking to the court's discretion as to how to proceed.
All right, thank you. This is what we'll do. We'll make a referral to MIDC for Mr. Ravenel. Put the matter on until the 21st of June. And we'll see what's what then. I want to make sure that MIDC does whatever they need to do to get with Mr. Ravenel to see if in fact his income exceeds their guidelines for appointment of an attorney. And we'll take it from there. So of course, going to make another referral on your behalf for an appointment of an attorney, Mr. Ravenel. But if in fact you are looking for an attorney, the court encourages you to continue to do so on the chance that you do, in fact, as was stated previously, exceed the income guidelines for the appointment of a court-appointed attorney. Okay, sir?
Yes, sir.
Mr. Ravenel, what is a good phone number and what is a good address for you, sir?
My phone number is 313-427-4527. My address is actually home, but I've been staying here and there in my car. So I don't have an exact place.
The retirement address is no good.
That's
sir?
that's my home, but I'm not there. You know, I can't be there with my wife.
There, sir.
I'm sorry, sir. What'd you say?
1 second, sir. All right, Mr. Ravenel, you're all set, sir. So the 21st at 9:45 is the next court date, June 21st. And we'll make again another referral and see where we are on the 21st. Okay, sir?
Yes, sir. Thank you.
Got something, Madam Prosecutor?
If the people may, is the complainant excused from this hearing?
Certainly.
Thank you.
All right, sir. Have a good day and be well.
June 31st. 21st.
June 21st at 9:45 a.m.
Yes, sir.
Have a good day.
All right.
Good morning.
Good morning, Your Honor. I'm here on Eric Matthews. It was set for review.
Yes, is Mr. Matthews here?
He is not.
Okay, so, how you gonna proceed?
I would ask to waive his appearance because the only thing that the court wanted to make sure Mr. Matthews did was pay that 600 in restitution. And we paid that the same day we were here last time.
Okay, let's, you call probation? Okay, just 1 second. Thank you.
Thank you, Judge.
Okay, thank you. Yes. Sorry?
It's about the zone man.
Okay.
Yes, sir. Rayshawn, yes. She's on the announcement.
Thank you. People ready on gray.
I'm sorry, Your Honor.
People ready on gray.
No, Your Honor.
Ready, Judge.
Will this court kindly provide a case number?
230-550-0701. Good morning, Attorney DiMaggio. One moment.
Oh, thank you, Judge.
Beyond the supplemental report, was there any other
There's a
documentation?
PSI. That was sent to Attorney Decker, I guess he made it. Madam Clerk, did you forward that to Attorney Solari? Or Mr. Gray?
Yes, sir. Thank you.
In the meantime, Attorney Roberts, have you spoken with everyone that you needed to talk to? That's a no.
Yes, ma'am.
All right, so let us go on the record. The court calls the People versus Rayshawn Gray. It's case number 230-550-0701. Matters before the court's sentencing. May I have your appearances, please, starting with the prosecution?
Carolyn Solari, P number 86651 for the People.
Thank you.
Andrew DiMaggio, P45619, on behalf of Rayshawn Gray.
All right, thank you. And may I have your name, sir? One more time, a lot louder, can't hear you.
Rayshawn Gray.
All right, thank you. And today being the date and time set for sentencing in this matter, the parties have received and reviewed the pre-sentence investigation report in this case. Madam Prosecutor.
Yes, Your Honor, people have.
Attorney DiMaggio.
Yes, and I've gone over it with Mr. Gray.
All right, are there any additions, corrections, or deletions that the court need make note of at this time?
I did not see any, Judge.
Madam Prosecutor.
No, Your Honor.
All right, is there anything prior to sentencing from the people?
No, Your Honor.
Attorney DiMaggio, anything you'd like to offer before sentencing?
Just that Mr. Gray is 25 years old and he wants to live his life right now, and he's trying to clear up his past dealings with the court.
All right, Mr. Gray, is there anything that you would like to say on your own behalf before the court imposes a sentence?
No.
All right, so this is what the court is going to do, sir. The court is going to place you on a probationary term that will be for a period of 1 year. That's 12 months. The court is ordering that you do the following within the 12 months as ordered. That is to complete the 26 weeks batter's counseling program. Of course, ordering that you have no contact with the complaining witness, Ms. Lacey. Of course, ordering that you not use or possess any handguns or firearms while you're on probation. You understand that, sir?
Yes.
Of course, further ordering that you not use or possess any drugs that you do not have a valid prescription for, including marijuana or any alcohol. You understand that, sir?
Yes.
Court is further ordering random alcohol and drug urinalysis, and that you complete a driver's improvement program and pay any and all outstanding traffic tickets in full. You understand that, sir?
Yes.
Mr. Gray, are you working, sir?
No, I'm on Social Security.
All right, court is ordering that you provide proof to probation of your attempt to participate or complete an adult education or GED program. You understand that, sir?
Yes.
And the court is further ordering 150 hours of the work program instead of any fines and costs. However, the court must assess a crime victim's rights fee that is $75. Court will assess probation oversight at $20 a month for an additional $240. There is the $100 substance abuse evaluation fee, as well as a urinalysis fee. Court will assess that at $120 for a sum of $535 to be paid through the probationary term. In the event that you test negative for any and all prohibited substances for 3 consecutive months, sir, the court will remove urinalysis testing as a condition of probation. However, if you test positive, the court is going to order you to outpatient treatment. You understand that, sir?
Yes.
All right, the court is placing this probation under MCL 7694A, which means, sir, if you successfully complete the terms and conditions of probation as ordered on today, this matter will be dismissed at the conclusion of the probationary term. You understand that, sir?
Yes.
What we'll do is we'll set a review date. That will be in, let's say, October. We'll make it October the 25th. That'll be at 10 a.m. and that'll be here in person at 36th District Court, 421 Madison, Detroit, Michigan, 48226 in courtroom 338. And we'll see and check in with your progress at that point. Okay, Mr. Gray?
Yes.
So that is the court sentence in this matter. Anything further from the people?
Your Honor, the people just wish to clarify, is the hearing scheduled for today?
10 a.m. October 25th, 2023.
Thank you, Your Honor.
Anything further, Attorney DiMaggio?
No, thank you, Your Honor.
All right, Mr. Gray, the court encourages you to get started with these probationary terms as soon as possible, as you have an opportunity to have this matter dismissed if you successfully complete probation. In the event that you do not comply with the terms and conditions of probation in this matter, I want to let you know that it is likely that you will go to jail on this case. You understand that, sir?
Yes.
All right, so we'll see you in October, and in October, we'll have a glowing report from probation about how well you're doing and how much you are making progress. We'll see you then. You have a good day and be well.
Okay, thank you.
Thank you,
Have a
Judge.
good day, Attorney Fangio.
Thank you. Thank you, Judge. You as well.
Thank you. Mr. Matthews, are you there?
Yes, I'm here.
All right, so the court calls the people versus Eric Matthews, case number 220-596-7501. Matter is before the court today for a review. May I have your appearances, please, starting with the probation department?
Good morning, Your Honor. Derek Farmer on behalf of probation.
Thank you.
Good morning, Your Honor. Carolina Ravenel, B49898 on behalf of Eric Matthews.
All right, thank you. And Mr. Matthews, may I have your name?
Eric Lamont Matthews.
All right, thank you. So I know this matter was, there was a plea taken, it was a delayed sentence, there was $600 in restitution to be paid. Mr. Matthews was to clear any and all warrants and not have any new cases. And so, Officer Farmer, is there a verification that that has occurred at this point?
Your Honor, as far as the balance is paid. I am currently waiting on the lien from our clerk to verify if he have any warrants. He doesn't have any that I synced from here.
Okay. Attorney Sprinkle.
Trying to ask the court to abide by the terms of the delay sentence and dismiss the charge.
All right, thank you. Officer Farmer, what's the estimated time of you receiving a lien report on Mr. Matthews?
It actually should be in about the next 3 to 5 minutes, Your Honor.
Okay, so in the event that that comes back clean, the court will sign any dismissal. Any event that it doesn't, we'll give Mr. Matthews a couple weeks to clear those up, and we'll come back then. And so tentatively, we'll have another date via Zoom on the 14th of June. If not, the court will sign a dismissal, and that'll go out via the mail.
Okay.
All right, thank you. Thank you, Mr. Matthews.
Did you write down that date, Mr. Matthews?
June what?
14th. June 14th, 10 o'clock, sir.
Thank you, Your Honor.
And if
All
it's
right,
still,
yeah,
Your Honor,
okay.
I'll submit the dismissal.
Okay, perfect. Thank you.
Okay.
Looking for me a Judge King.
Better hurry up.
Last time I was late, he had his charges.
Don't want that.
Have a good day.
You too, thank you. Time and patience.
Thank you.
Prosecutor.
Yes.
Wait a minute, let me,
Attorney Cole, good morning. Who do you have with us on today?
I have 3 sentencings with you today with Flowers, Matthews, and Williams.
Okay, Matthews was a review. We've done that already.
Oh, I'm sorry. That was a review. I apologize. That was a review.
However, we're waiting on defense counsel for Flowers and Williams.
And then also we had Nezari Gregory scheduled for trial, but it was just a matter to see if he was going to do the anger management.
We didn't. Yeah, we already moved that date, Attorney Cole.
Oh, that's right. I remember that now. Was he? Yeah. Okay, so I can cross that one off.
Yes,
Okay.
ma'am.
So we're just waiting, I think, on Arthur Williams. That's the Perkins Law Firm.
Yeah, they phoned the court, said they're sending someone over on that one.
Okay.
And so we're waiting on Attorney Roberts on the other matter, and then we'll take it from there.
Okay.
Thank you.
Thank you. That's right about Gregory Nazareth. We did move back on anything. Oh, boy.
Attorney Roberts, are you ready on Fields?
No, I have to go back in with Mr. Fields. I'm ready on Mr. Flowers and Mr. Amos, though.
Okay. Let's you said you need to speak with Mr. Fields.
Yes, again, please.
All right, Mr. Edwards, sit tight for us. Appreciate your patience. All right, let's do Flowers. The court calls the People versus Thomas James Flowers, case number 220-440-5201. Matter is docket for sentencing on today. Appearances, please, starting with the probation. Starting with the People.
Follow call on behalf of the People.
Thank you.
Good morning, Amanda Roberts appearing on behalf of Mr. Flowers. Mr. Flowers, can you state your name, please?
Thomas Flowers.
Thank you.
All right, thank you. And the parties have received and reviewed the pre-sentence investigation report in this matter. Madam Prosecutor.
Yes, Your Honor. Yes, Your Honor.
Yes, Your Honor.
All right, any additions, corrections, or deletions that the court need make note of?
Not on behalf of the People.
None from defense, Your Honor.
All right, and is there anything prior to sentencing from the People?
No, Your Honor, I just thought I was a little disappointed that it doesn't appear that Mr. Flowers is taking responsibility for what he did. So I'm a little concerned about that.
Okay.
I don't see any contrition, I guess is what I should say.
Understood. Attorney Roberts?
Your Honor, Mr. Flowers is here for sentencing, and at the last court hearing, he did plead to this, so that plea alone, Your Honor, would be Mr. Fields accepting responsibility. I do believe that he is prepared to address the court and make somewhat of a statement today, but as it relates to the recommendation, Your Honor, Pierce Probation is asking for a very lengthy period of probation, and I'm going to ask the court to sentence what I think would be accordingly, where the only charge before the court here is malicious use of telecommunications service. And I'm going to ask the court to consider a period much less than 18 months of probation and ask for a 6 months probation. I would just note that Mr. Flowers is employed as a truck driver, so we would ask that you not impose community service. The issue is that Mr. Flowers in his employment is sometimes only home 2 to 3 days, over a 2-month period. And I believe the court had previously granted Mr. Flowers the opportunity to travel for purposes of employment. I'm going to ask that the court continue that on his probation as long as it does not interfere with his probation. But I'm asking that the court consider that as it relates to the imposition of community service. Other than that, Your Honor, this program that they're recommending, I guess I need more information about that because I'm not sure how that correlates, what exactly that program is. I don't know that I've seen that before. So I'm not sure exactly what they're recommending or how that applies here. So I'm going to ask the court to either enlighten me or to make an independent decision as it relates to how that program, this aggressive self-realization program, is relevant or has nexus to this matter. But simply, I think no contact is important, and I would leave it to Mr. Flowers to address the court at this time if he so feels.
All right, thank you, Attorney Roberts. Mr. Flowers, is there anything that you would like to say on your own behalf before the court imposes a sentence in this case?
Yes.
You may proceed, sir.
I just want to say I'm sorry for my actions, and I want to put this behind me and move forward with my life. So I'm ready. I'm at the court's mercy of everything that you have going on for me.
Okay. All right, so this is what the court is going to do. The court is going to place you on probation, sir, for a period of 12 months. The court is ordering that you have no contact with the complaining witness and that you not use or possess any handguns or firearms while you're on probation. You understand that, sir?
Yes, sir.
The court is further ordering that you not use or possess any drug that you do not have a valid prescription for. That includes marijuana, and that you do not consume any alcohol while you're on probation. You understand that, sir?
Yes, sir.
As such, the court is going to order random drug and alcohol urinalysis. In the event that you test negative for any and all prohibited substances for a period of 3 months, then the court may remove urinalysis testing as a condition of probation. However, if you test positive for any prohibited substance, the court is going to order you to attend and complete outpatient treatment. You understand that, sir?
Yes, sir.
The court is further ordering that at this point you, of course, going to assess a fine of $500. The court is also going to assess costs at $115, plus a $75 crime victims' rights fee. Of course, going to assess probation oversight at $240 a month. There's an additional $100 substance abuse valuation fee, and court is assessing $120 as a urinalysis fee. So that brings that total to $1,150 to be paid through the probationary term. We'll set a review for this case in October. That'll be October the 25th. That'll be at 10 a.m. And that'll be in person here at 36th District Court. The court at this time is going to order as recommended, the self-realization program with a consideration to focusing on the specifics of this particular matter as it relates to accountability and utilization of telecommunications devices in a malicious fashion. That is the court sentence in this matter. Anything further from the people?
No, Your Honor, thank you.
Attorney Roberts, anything further?
Your Honor, can we have his order of probation reflect, if the court's willing to continue giving permission for him to travel, can that be reflected in the order as well, just so there's no issues with anything moving forward?
Any response from the people?
If it's solely for work, I would have no objection to it.
All right, court will issue a standing order as it relates to Mr. Flowers traveling for work purposes only. If there's some leisure or vacation travel, the court is ordering that permission be granted separately. Requested and granted separately. And so we'll take this matter up back on October the 25th, and we'll see where we are then. Thank you and have a good day, Mr. Flowers.
Thank you.
Thank you, Your Honor.
All right, that was been all for you then, Attorney Cole, correct?
There's Arthur Williams.
Oh, we're waiting on counsel. I'm sorry, I forgot about that one. You need to speak with Mr. Fields again, Attorney Roberts.
Yes, I am ready on Mr. Amos, Your Honor.
All right, people ready on Amos?
Yes, Your Honor, we're ready.
All right, so the court calls the people versus Javonte Amos, case number 230-443-7001. Matter set for sentencing on today. Appearances, please, starting with the prosecution.
Carolyn Solari, P number 86651 for the people.
Thank you.
Deandra Roberts appearing on behalf of Mr. Amos. Mr. Amos, can you state your name, please?
Javonte Amos.
All right, thank you. And today is the date and time set for sentencing. Parties have received and reviewed the PSI in this matter.
No, Your Honor.
Madam Attorney Roberts, have you received and reviewed the PSI in this case?
Yes, Your Honor.
Are there any additions, corrections, or deletions that the court need to make note of?
No, Your Honor.
All right, Madam Prosecutor, Madam Clerk's going to forward you the PSI again.
Thank you.
One moment, Mr. Amos.
Now, Bert, is it just the one-page document?
PSI in this case is 7 pages.
I previously received the one-page document.
How's it going?
Oh, you got stuck in the evidentiary. That's why I was trying to. You guys got a sentence report? Let's see, PSI. What is that? For Mr. Williams. Did you get it? Did you get my back? I tried early because I know you get busy.
I see here at 8:58. Yeah, I didn't.
Yeah. Well, you know, I had actually signed on at 8:30. Can I get that?
Sure, you can take a look at it.
Yeah, I don't know if he's ready for that. Thank you. But,
Can I see a copy of that?
Madam Clerk wants to see it.
Oh, not that. No, I'm saying for Javonte Amos. I'm sorry. The one for
Oh,
tomorrow.
you can take that.
Okay, all right, I'll be back in a second. Thank you.
Attorney Roberts, did you speak with Mr. Fields?
Yes, but I'm not finished. I needed more time with him, please, Your Honor.
Oh,
You want me to do that now?
yes, because Madam Prosecutor has not yet reviewed the PSI in Amos.
Got it. I'm going now. Thank you. And I believe we are ready on Miss Smith too.
Okay.
Thank you. Thank you, Your Honor. Mr. Fields is back. We're ready on Fields.
All right, so let us go on the record. The court calls the people versus Joseph William Fields. It's case number 230-442-0501. Matter is before the court today for a continuation of the final pretrial conference. May I have your appearances, please, starting with the people.
Carolyn Solari, P number 86651 for the people.
Thank you.
Good morning, Your Honor. Andra Roberts, P76414, appearing on behalf of Mr. Fields. And Mr. Fields, can you tell the court your name, please?
Joseph Fields.
The court notes also has a list of complainants in this matter present. May I have your name, please, ma'am?
Tina Edwards.
All right, thank you. And Attorney Roberts, what is your pleasure in this case at this time?
Your Honor, it's my understanding that people have made an offer, that offer being attempted reckless use of firearms with a plea agreement and for a probationary period of 6 months sentence agreement. At this time, Mr. Fields, after having the benefit of counsel, does wish to waive his rights incident to trial and offer the court a plea of guilty pursuant to that plea agreement.
All right, thank you, Madam Prosecutor. Is that an accurate recitation of the people's offer in this matter?
Yes, Your Honor.
All right, thank you. Mr. Fields, is that what you'd like to do on today?
Yes, Your Honor.
All right, will you raise your right hand for me? Do you swear or affirm to tell the truth and nothing but the truth so help you?
Yes, I do.
All right, you can put your hand down, sir. 1 second. All right, so let us go back on the record. Mr. Fields, you understand that you do have a right to a trial in this case?
I do. I do.
And today you are waiving or giving up your right to a trial by accepting the offer from the prosecution and pleading guilty?
Yes.
You're doing so voluntarily, knowingly, and intelligently?
Yes.
No one has promised you anything or threatened you in any way to get you to do so?
Yes.
Someone has promised you or threatened you to get you to plead guilty here today?
No, sorry about that. Sorry about that.
You're doing so on your own free will?
Yes, I am.
And you understand that once the court accepts your plea, that there will be no trial of any kind in this case?
Yes, I do.
You understand that by offering this court a guilty plea on today, you're waiving or giving up your right to have the people prove beyond a reasonable doubt that you are guilty.
Yes, I do.
You're waiving or giving up your right to cross-examine or question any witnesses and or review any evidence that the prosecution would put forth in support of their case.
Yes, I do.
You're waiving or giving up your right to have witnesses testify on your behalf.
Yes, I do.
And you're waiving your right to remain silent and not have that silence be used against you.
Yes, I am.
And you're doing so on today with the understanding that a conviction for attempted reckless use of a firearm does carry up to 45 days in jail and or a $500 fine.
Yes, I do.
And you're pleading guilty today nonetheless.
Yes.
And you're pleading guilty today because you are in fact guilty.
Yes.
So as to count one as amended to attempted reckless use of a firearm, how do you plead, sir? Guilty or not guilty?
Guilty.
All right, thank you. Factual basis, Attorney Roberts.
Yes, Mr. Fields, on February 14, 2023, were you at an address on Rossini in the city of Detroit?
Yes.
Okay, and on that date at that location, did you fire a firearm at the ground?
Yes.
I'm satisfied, Your Honor.
Are the people satisfied?
One moment, Your Honor. Your Honor, it's the people's understanding that the bullet was found on the ground, not that it was fired at the ground.
The distinction being?
Sorry, Your
The
Honor,
distinction being?
that it wouldn't necessarily be an accurate factual basis. People are willing to proceed otherwise.
Hold on a second. If I fire a bullet at the ground,
They found the casing, I'm sorry, Your Honor.
okay. So the distinction then is what? If I'm firing a gun and the casing comes out and the casing's on the ground, then I fired the gun, right?
Yes,
Okay, so your objection is to?
just the conclusion that it was fired at the ground. That was not something that was indicated in the investigative report.
Okay, so where was the gun fired then as far as, so that would satisfy the people?
Unknown, Your Honor.
Well, if you don't know, why would you say it wasn't fired at the ground?
Because it wasn't proven to be fired at the ground, Your Honor. That's what I'm trying to get at.
Well, no, he's saying that's what he did.
Okay,
And sir, you did so in a reckless manner, correct?
Yes, I fired the gun at the ground.
Okay, court is satisfied. Are people satisfied?
yes.
All right, the court will accept the factual basis as well as the guilty plea as to attempted reckless use of a firearm and will accept the guilty plea as it relates to attempted reckless use of a firearm. As such, we will set a sentencing date in this case. Let's make that for the, come back on July 14th. That's a Friday. That'll be at 10 a.m. That will be via Zoom. The court is ordering a pre-sentence interview and a substance abuse evaluation to be conducted prior to sentencing. Ms. Edwards, if there's a statement that you would like to make, written or otherwise, the 14th at 10 a.m., 14th of July, that is, at 10 a.m. is the appropriate time to do so. Okay, ma'am?
Yes, sir.
All right, and we'll move the matter along with sentencing on that date time. Anything further from the people?
No, thank you, Your Honor.
Do you have a signed plea agreement or a plea offer?
No, Your Honor.
Attorney Roberts?
We don't have one as well, Your Honor. We would need that from the people.
I'm sorry, go ahead.
We would need the people to execute that first.
All right, so let's have that for the court file, certainly prior to sentencing day. So that's the conclusion of the docket if you need to work on that. All right. Thank you, Ms. Edwards, for your, I'm sorry, go ahead, Attorney Roberts.
Two things. Did you say Mr. Fields is in person or Zoom hearing for sentence?
Let's do that in person.
Okay, and second, Your Honor, can I address bond?
You may proceed as the bond.
Thank you. Now, Mr. Fields' concern in this case is wanting to return home. And I know that we did speak to the people about this, and based upon their conversation with the complainant, had indicated that they would not be amenable to modifying the bond at this time. However, Mr. Fields does want me to bring to the court's attention that he does have medical condition, which I do believe he has seizures, and he's currently at his mother's, and he's of the position where he needs medical assistance, Your Honor. And to my understanding, no one's able to care for him while she's at work. And his cousin could stay with him at home if he were able to return there, as well as his concern about taking care of the property. And so that's just what he would like to be placed on the record, so that we can ask the court if there's any possible entertainment of returning to that location. I believe it's the Rossini address with a no assault of contact provision.
All right, the people's position is?
Your Honor, the people have spoken to the complaining witness in this case, and she has told us that she does not feel comfortable, and she was adamant that she does not feel comfortable with the defendant returning back to the home address.
All right, so I mean, if that's the people's position, and that's what the information that they've gotten from the complainant, the court's going to continue bond. I'm not going to, in this situation, in light of the facts that got us here, in light of the conviction now at this point, order that Mr. Fields and Ms. Edwards now again have to reside together. So, of course, going to continue bond in this particular matter. Anything else, Attorney Roberts?
No, Your Honor, thank you.
All right, thank you all for your patience. You all have a good day and be well. I'll see you all in July, if not sooner. Thank you. Could you call Attorney Cole for me? Because she's now gone. Attorney Bergen. You're ready on Amos though, aren't you, Madam Prosecutor?
Yes, Your Honor.
I can touch.
Please do. All right, so let us go back on the record in the People versus Javonte Amos. Madam Prosecutor, you now have reviewed the PSI in this case.
That is correct, Your Honor.
Are there any additions, corrections, or deletions that the court need to make note of from your end?
No, Your Honor.
All right, anything prior to sentencing from the people?
No, Your Honor.
Attorney Roberts?
Your Honor, we do believe that there's a plea agreement in this case for MCL 769.4A. So we are asking the court to adopt that plea agreement at this time. The only other thing, Your Honor, is that it looks like probation is asking for outpatient. However, I would just note that the pre-sentence report does seem to reflect that when he tested on April 29th, it was negative for all substances. I would ask the court to consider refraining from imposing any outpatient or inpatient at this time, and to only impose that if there is a positive test moving forward.
All right, thank you. Anything else, Attorney Roberts?
No, thank you, Your Honor.
All right, Mr. Amos, is there anything that you would like to say on your own behalf before the court imposes the sentence? You have to unmute your device so we can hear you.
Can you hear me now?
I can hear you now, sir. Anything you'd like to say?
I'm just ready to put, all this behind me. I made a mistake, and it won't happen again.
All right, thank you, sir. What the court is going to do is adopt the recommendation from the probation department to this extent. Court is going to place you on probation for a period of 12 months, that probation being under MCL 769.4A. And in the next 12 months, the court is ordering that you attend and complete 26 weeks of VATRS counseling, and that you don't have any contact with the complaining witness. You understand that, sir?
Yes, sir.
Court is further ordering that you not use or possess any handguns or firearms, and that you abstain from using or consuming any alcohol or any drug that you do not have a valid prescription for. You understand that, sir?
Yes, sir.
Court wants you to know that in the event that you test negative for a further 2 months for any prohibited substance, then the court will remove the urinalysis testing for random urinalysis testing that is ordering for drugs and alcohol. However, if you test positive at any point during probation for any prohibited substance, the court will order you to outpatient treatment. You understand that, sir?
Yes, sir.
All right, the court is lastly going to order that you complete 12 days of community service instead of any fines and costs. However, the court is going to assess a $75 crime victims' rights fee, probation oversight at $20 a month for an additional $240, the $100 substance abuse evaluation fee, and a urinalysis fee of $120 for a sum of $535 to be paid within the next 12 months. As it relates to that urinalysis fee, in the event that the court removes urinalysis testing as a condition of probation, or you and your probation officer work out a different location for you to test where you pay that location directly, the court will waive any corresponding fee. What we'll do is we'll set a review for this case. That'll be in November. We'll come back on November the, let's say November the 8th. That'll be at 10 a.m. That'll be here in person at 36th District Court, 421 Madison, Detroit, Michigan, 48226 in courtroom 338. Again, that date is November the 8th. The time is 10 a.m. and that's here in person. And we'll have a review of your progress as it relates to the terms and conditions of probation as ordered on today. That is the court sentence in this matter. Anything further from the people?
Your Honor, would that include the no contact with the complaining witness?
Yes.
Okay, thank you.
Anything further, Attorney Roberts?
Your Honor, I believe back on April 19th, the court amended bond to allow for a third-party contact. Ada Brown? Did that get?
Yes. No.
Okay, so that's still in effect for these parties.
That is correct.
Thank you.
So, Mr. Amos, will see you in November, if not sooner. The court is encouraging you to get started as soon as possible so that you can get this probation done, and so that you can put this matter behind you as you stated that you wanted to do. Okay, sir?
Yes, sir.
All right. You have a good day and be well. See you in November.
You too.
Thank you. All right. I think that's everyone but Ms. Smith and Mr. Williams. And I don't have Attorney Cole back on Williams.
Your Honor, what about Defendant Grady?
The jail or whomever has him has not zoomed in at all.
Okay.
I know he was on yesterday, but Attorney Roberts indicated he had another matter set for today, so I wish we had known that yesterday.
Ready for Smith?
I'm ready for Smith.
Come on in, Ms. Smith.
All right, so the court recalls People versus Marion Smith. Appearances yet again, please, starting with People.
Carolyn Solari, P number 86651 for the People.
And good morning, Ian Roberts appearing on behalf of Ms. Smith. Ms. Smith, can you state your name?
Marion Marie Smith.
All right, where are we with this matter, Attorney Roberts?
Your Honor, after having benefit of counsel, Ms. Smith wishes to waive her rights incident to trial. She is going to offer the court a plea of no contest pursuant to the plea agreement, which we already placed on the record, but just to remind the court, it would be to 1 count of domestic violence with the child abuse charge to be dismissed.
All right, thank you. And Ms. Smith, is that what you want to do on today?
Yes.
Are you sure?
Yes, sir.
Your Honor, I'm sorry, I forgot to say under MCL 769.48.
That is correct, right, Madam Prosecutor?
Yes, Your Honor, it is.
All right, that is what you want to do, ma'am?
Yes, sir.
You raise your right hand for me. Do you swear or affirm to tell the truth and nothing but the truth, so help you?
Yes, sir.
All right, put your hand down. Ma'am, you do understand that you have a right to a trial in this case?
Yes, sir.
And today you are waiving or giving up your right to a trial by accepting the offer from the people and offering the court a no contest plea.
Yes, sir.
Attorney Roberts, what's the basis of the no contest plea?
Your Honor, potential civil liability.
All right, thank you. And ma'am, you understand that a no contest plea on today, for today's purposes in this court, does have the same effect as a guilty plea. Do you understand that? You understand the difference? Attorney Roberts, would you assist her?
Sure.
Okay.
Okay, I believe she understands, Your Honor.
All right, so you understand it does have the same effect as guilty plea in this court.
Yes,
And so you're offering that plea voluntarily, knowingly, and intelligently.
yes,
No one has promised you anything or threatened you in any way to get you to do so.
no,
You're doing so on your own free will.
yes,
And you understand that once the court accepts your plea, that there will be no trial of any kind in this case.
yes,
You understand that we're offering this court a no contest plea on today. You're waiving or giving up your right to have the people prove beyond a reasonable doubt that you're guilty in this matter.
yes,
You're waiving or giving up your right to cross-examine or question any witnesses and or review any evidence that the people would put forth in support of their case at trial.
yes,
You're giving up your opportunity to have witnesses testify on your behalf.
yes,
And you're waiving your right to remain silent and not have that silence be used against you.
yes,
And you're doing so on today with the understanding that a conviction for the crime of domestic violence does carry up to 93 days in jail and or a $500 fine.
yes,
But you're offering this court a guilt, right there, you're offering this court a no contest plea on today nonetheless.
yes.
So as to count, I think it's count one, count two, domestic violence, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, thank you. And the parties are stipulating to the investigator's report and the complaint for the factual basis of the no contest plea.
Yes, Your Honor.
Yes, Your
All
Honor.
right, and for the purpose of the record, count two in the complaint reading that Miss Marion Smith did make an assault or assault and battery upon Robert Beard, an individual with whom she had a child in common and or an individual with whom she had a dating relationship. Court is going to accept the stipulation to the complaint and investigation report as the factual basis for the no contest plea on today. Court will therefore also accept the no contest plea as to count two domestic violence in this matter. Court is going to order a pre-sentence interview and a substance abuse evaluation in this case, which is Ms. Smith, where you will meet with the probation department here at 36th District Court. They're asking questions about yourself. You'll answer those truthfully, honestly, and to the best of your ability. They will create a report that will be provided to you, to me, and to the prosecution about what they recommend based upon your answers to those questions as far as sentencing goes. To have that done before we move forward with sentencing, and we will move forward with sentencing on the let's say the 14th of July. Let's make that here in person, that same courtroom, 10 a.m. And we'll see where we are with the matter at that date and time. Anything further from the people?
No, thank you, Your Honor.
Anything further, Attorney Roberts?
No, Your Honor, thank you.
All right, Ms. Smith, we'll see you in a few weeks. You have a good day and be well. Thank you for your patience this morning. Attorney Cole back on. Time is just coming together. You ready?
Yes.
All right, so once they clear the space, you all are all set.
No, no.
Okay, wait, hold on, let me see if she's okay with that.
Okay.
She's trying to get some work for me. I get it. I mean, for text me now, like on your way out. Okay?
Gotcha. Thank you.
All right, Attorney Cole, you ready on Williams?
Yes, Your Honor.
All right, Attorney Perkins is here, he's ready. You still have that PSI, you can provide that back to.
May I approach, Your Honor?
Yes.
Thank you.
All right, thank you. So let us go on the record. The court calls the people versus Arthur Rayshawn Williams, case number 210-444-3501. Matters before the court today for sentencing on today. May I have your appearances, please, starting with the people?
Paula Cole on behalf of the people.
Thank you.
Good morning. Yes, good morning, Your Honor, and good morning to your staff. May it please this honorable court. My name is Todd Russell Perkins, P 55623, appearing on behalf of Mr. Williams. Mr. Williams?
Arthur Williams. All right, thank you. And today is the date and time set for sentencing in this matter. Parties have received and reviewed the pre-sentence investigation report. Attorney Perkins?
I have, Your Honor, and had an opportunity to review with Mr. Williams.
Madam Prosecutor?
Yes, I have. Thank you, Your Honor.
All right, any additions, corrections, or deletions that the court need to make note of on today?
Not on behalf of the people.
No additions, corrections, or deletions. I do have some, what I hope to believe, some persuasive arguments on behalf of this.
All right, so one moment for those. Madam Prosecutor, you have anything that you would like to say prior to sentencing?
Well, I really sincerely hope that he is in a alcohol highway safety education program as indicated in the pre-sentence report, because after this case was in 2020, and in 2023 picked up another alcohol related offense. So I think that he's clearly in need of random drug urinalysis, and he should be required as indicated on page 2 of the pre-sentence report. I think it's very important that he's in an alcohol highway safety program. That's all I have to add.
Okay, Attorney Perkins.
Yes, may it please the court. Your Honor, I would ask the court to issue whatever fines and costs in this matter, and I'd ask that this matter be closed out. And this is the reason. I don't want to be flippant. I don't want to negate the benevolence that's been shown us by the government in this matter either. But if the court recalls, and with Mr. Bradfield, who was the author of this report, he did I believe a yeoman's effort in researching what Mr. Williams is going through in the 47th District Court. It's merely replicating. So to Ms. Cole's request, he's already accomplished those specific line items like highway safety program, but he's also in an intensive alcohol treatment program as referenced in that report. And that's one of the things that I can compliment the program here of having done a good write-up as it relates to the background of Mr. Williams. No, I'm not saying give him a pat on the back because he got another case and has that, but the requirements, even as Mr. Bradfield or Agent Bradfield recommended to the court here, he's far exceeding those requirements in that case, and that he's currently under a term of probation that actually exceeds the amount of time that would be recommended here. Doesn't mean that this court would have to follow that, but at the end, at this point, I believe he is doing all of the work that this court would require of him. And I would ask, and to the extent the court wants to have its concerns that those things are being done, keep it open for the time being so that we can provide that information. I don't know if Mr. Bradfield would be the person who would be supervising, but allowing that individual to, or not that individual, he's standing right by my right side, Mr. Williams, to provide that information, which would accomplish, I think, the specific request of the prosecutor, but also looking at what he's doing in that particular probationary term and how he's complying. I think we're accomplishing the goals of him getting back on path. He's paid, he is on his road to Damascus. As you can see, he's paid severely for this. He had a job making $40 an hour, $39 an hour, and had it for about 20 years. And now he's found work, but now he's working at $16 an hour. That's definitely something that he's going to be clawing his way back. Now, there's some other issues that we're representing him on, or potentially representing him on some civil matters. But again, it is definitely a light is on and moving forward and trying to see himself to the other side.
Thank you. Thank you. Mr. Williams, is there anything that you would like to say on your own behalf?
I think he took a no contest plea in this, if I'm not mistaken, because there was an accident. I thought he took a no contest plea, but I don't know if I was the person. Sure. He should have. No,
it was guilty.
Okay. Well, Mr. Williams.
It was guilty. Go ahead, Mr. Williams, if you'd like to say it.
I mean, for one, I would like to apologize just for my time here. I mean, I think I'm wasting your time just by my reckless decisions back in 2020. I recently made another mistake and I'm paying severely for it. And I'm just on the road to recovery as far as just getting my life back and just pleasing the court and society and my family.
Right. I would notice his father's here with him today, just didn't come into the court.
You here for support?
Yes.
Is he in the hallway?
Yeah, he in the hall. You want me to go get him?
Grandfather.
Well, I was just saying, I don't think he wants to.
Oh, he doesn't want to come
He don't
in?
want to
If
speak.
he come in, if he wants,
I
if he wants to
just-
say something, he can come in.
Well, you want me to get him, Judge?
You don't have to get him. No, you don't have to get him.
I just thought I'd say that he does have, it's interesting that my dad cut his uncle's hair. So that's how long, I've not known him only a little bit, but known the family, that's.
So I guess this is where the court is philosophically as it relates to what should happen here. I think that what has been ordered out in Farmington Hills is extensive. And philosophically, the court I don't think that anything is gained necessarily by having you repeat or having a duplicative, I guess, demand of you as it relates to probation in this particular case. What this court is going to do, though, as far as sentencing, is this. The court is going to adopt at least a lot of what is in this recommendation. So I'm going to order that you attend the victims impact panel, that you submit yourself to random drug and alcohol urinalysis, that you complete the driver's improvement program, and that you attend and complete the alcohol highway safety education course. And so I'm ordering that, and that's going to be part of the order. If that is those are things that you have already completed to this point in this year since you've been sentenced in 47th District Court, provide that information to the probation department here, and that'll satisfy me as far as the court's order for you to do those things. If that stuff has not been completed or something analogous has not been completed, then that's something that you're going to have to do. Well, let me finish before you ask any question. The court at this point notes that there were $1,915 in court costs, fines, costs, and supervision fees assessed. Otherwise, the court's not going to assess any fine in this case. The court's going to order those community service hours. I note that it's 30 days listed here. The court is going to order 21 days of community service to be completed through probation in the next year. However, there is a $75 crime victim rights fee that must be assessed. Probation oversight at $240, that's $20 a month, and a $100 substance abuse evaluation fee. So that sum is $415 to be paid through probation in the next year. We'll set a review date for November to see where you are with respect to what this court has ordered, as well as to the extent that there's any duplicative thing that you're doing between 47th District Court and this particular district court. And so we'll have a review for let's say November 13th at 10 a.m. and that'll be here at 36th District Court. You come back down here and hopefully we'll be able to get to you a little sooner than 11:30, but we're waiting on attorneys. I was here. And that is the court's sentence in this matter. You have a question, sir?
You said provide the information. I believe I provided the information.
If they have it already, then that's fine. You don't have to give it to them again. But for the purposes of this court's order, those are things that I'm ordering you to do. And you just give it, or if you've given it to them, that will satisfy probation. It'll satisfy the court as those things haven't been completed. Anything further, Attorney Perkins?
No, Your Honor, thank you.
Anything further, Attorney Cole?
No, Your Honor, thank you.
All right, thank you. So, that's that. You all have a good day and be well.
Thank you so much, Your Honor.
Did you represent him out in 47th District Court as well?
Yes.
Okay. All right, thanks, Attorney Cole. Have a good day.
Thank you, Your Honor.
I'll see you.
Let us go on the record. The court calls the People versus Quinter Grady, case number 230-446-8901. Matters before the court today for a pretrial conference. Appearances, please, starting with the prosecution.
Carolyn Solari, P number 86651 for the People.
Thank you.
Deidre Roberts appearing on behalf of Mr. Grady. Mr. Grady, can you state your name, please?
Yes, ma'am. Quinter Grady.
All right, thank you. And Attorney Solari, what is the people's pleasure in this case at this time?
Your Honor, at this time, the People would need some time. I was under the impression this was a general warrants matter. And it seems like the defendant is in the process of being sentenced for another matter. So I would just ask for an adjournment.
All right, Attorney Roberts.
Your Honor, we move for dismissal and absence of the complainant today.
All right, thank you. The court is going to deny the motion to dismiss. With pleasure otherwise, Attorney Roberts.
Respectfully ask for a final pretrial conference and that the complainant be present at that next court date.
All right, thank you. That is what we'll do. We'll set the matter for 1 second. Set the matter for a final pretrial conference. That'll be on the 14th of June. That'll be at 9 a.m. Court does want to complain when it's present if the people are proceeding in this matter with that individual's assistance, and will do so as needed at that date and time. Anything further from the people?
Your Honor, did you state 9 a.m.?
9 a.m. on the 14th.
Thank you.
June 14th. Attorney Roberts.
Nothing further. Thank you.
All right, Mr. Grady, we'll see you in a few weeks. Have a good day and be well.
Thank you. You too.
All right, that is